Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about probate claims in Iowa. So, probate is a court case that is often necessary when someone passes away in order to give the executor or administrator of the estate the power to distribute the deceased person's assets first to anyone they owed money to, known as creditors, and then if there's anything left over to beneficiaries under the will, and if there is no will, then to heirs. Those are the people that state statute says are entitled to inherit in the absence of a will. But the creditors have to be paid in full first before the beneficiaries of the will or the heirs can receive anything. If there's not enough money to go around to pay all the creditors, then creditors get paid in order of priority. So certain creditors have a priority claim, and those are generally creditors that have a security interest in some sort of property like real estate. A mortgage will have priority over a credit card debt. So the mortgage will be paid first before the credit card debt if there's not enough money to go around. But before the creditor even throws their hat into the ring to be paid by the estate, they have to file a claim with the probate estate. Creditors who are owed money by the deceased person or by the estate will not get paid, and their claim will be any claim they have will be barred, and they won't be paid from the estate if they don't file a claim with the probate clerk by the deadline. So let's talk about these deadlines. One of the first things that the executor or administrator will do after filing the probate case will be to send notice to known creditors. These are people that, through reasonable investigation, the executor or administrator is able to discover that the deceased person owed money to. So they'll receive a personal notice mailed to them that the probate estate has been opened. Once this notice is properly sent and received, the known creditors will have 30 days from the date of that notice to file a claim against the estate. If they don't do so, even if they were legitimately owed money by the estate, their claim will be barred and they won't be paid out of the estate. But there might be creditors that the executor or administrator don't know about through reasonable investigation. And for this reason, they are required to file a notice publish a notice in a newspaper of general circulation in the county in which the probate case is being held. This notice is published multiple times, but there's a 4-month deadline for unknown creditors to file claims against the estate, and that deadline runs from the second date of publication. So the second time it's published in the newspaper, 4 months from that date will be the deadline for any creditors who did not receive personal notice to file claims. So again, if you're a known creditor and you got mailed a personal notice of the probate estate, you've only got 30 days to file the claim. If you didn't receive this personal notice and you believe you're owed money by the deceased person or the estate, you have 4 months to file the claim. If you don't file by those deadlines, then even if you have a valid claim, your claim will be barred, and you won't receive any money from the estate. So what is this claim that you have to file? It's a simple form that you get from the clerk of the county in which you're filing. Sometimes the clerk will not have a form, and you'll have to have an attorney create the form for you. But the form basically lays out the amount of the claim, the nature of the claim, and evidence to prove that the claim is valid. This form will be provided to the clerk, and the executor or administrator will receive a copy as well. At that point, the executor or administrator will have the option to allow or disallow the claim. If they're going to pay the claim, if they agree that the claim is valid and it's going to be paid in full, then really that's the end of things. They'll provide an accounting to the creditor showing how the money will be paid and that all claims against the estate will be paid, and there's really no dispute. If the executor or administrator believes that the claim is not valid, then they can choose to send notice that they are disallowing the claim. This notice has to be sent to the claimant and their attorney of record by certified mail. And then once the claimant receives notice that the claim is not going to be honored by the executor of the estate and they're not going to just be paid in full through the normal probate process, then the claimant has the option to request a hearing. They file a request for hearing with the probate clerk and mail that request to the personal representative. So at this point, you enter litigation, and you follow the normal rules of civil procedure for litigation, which ultimately culminates in a trial, at which point the probate claimant has to prove that the claim was owed to the estate, and the executor or administrator will try to disprove that the claim was owed to the estate, the burden of proof being on the probate claimant. At the end of the trial, if the judge agrees with the claimant, then the judge will order that the claim be paid out of the estate. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.